Nsem-Pii TV nie.
And right for Becca, report to Eddie Mamo, say Richard Jakpa, any the lawyers. Tadio sorry, Bassett Bamba, and Edugita Mankulu. Say, Nka, Omobe hold to trial process, no, Ombe prevent Yamame, Justice if you are Sewas from pronouncing the determination and the judgment of applications and done in no. Now, your report to Eddie Mamo, so moderate Aquacotum Supreme Court. But now you can save Justice if you are Sewas na ennei na babeto dwa se court to them ho almost original through the lawyer Tadio sorry a raise objection say when na maame no pronounce judgment when no really is answer o file rate e Supreme Court of Ghana pending hearing and no na ye maame Justice if you are Sarabutwi nsem odi to dwa no afei na babeto dwa o ka kire Tadio sorry ene Richard Jakpa say he me nsan kan read bia free Supreme Court we e ya me court asem no me na damanim in the application I have jurisdiction to bring a determination into the Maya Marvin Semekana and one American won't me stop me. After number 2, say a frame Supreme Court, some Bramiano and couldn't tell some no honor. We did determination as judgment by 2 jar. Oh, Japa, no lawyer Tadio sorry. Mummy no, mention my frame of Supreme Court to be. I'm most my baby chim and the couldn't tell someone. Momo say, Munni for, yen yamo, yen drop charges in against him, didn't and I'm smooth Supreme Court. Just say, and Seminole, I had the jar. Now, young court name good tea, and Seminole and Cassa, Justice if you are Sarabutwi, or the 2 jar concerning the Supreme Court writ against her.
When we went to the court yesterday, before the judge began the reading of her rulings, Tadio Sorry, who is lawyer for the third accused person,
Richard Jakpa,
right, rose up to say that he has filed an application at the Supreme Court. Essentially, that application was seeking to arrest the delivery of the rulings. And so he was drawing the attention of the judge. Then the judge answered and said that, well, she's sitting as a high court judge. She has applications before her. It has been moved and she's been invited to give a ruling. If there is any application at the Supreme Court, it doesn't come to her notice. And in any case, she will go ahead and deliver her rulings. If she is ever caught in contempt at the Supreme Court, she will invite Tadio Sorry to defend her.
No, that's skill.
That is justice. If you ask Sarabutwi, Justice of the Court of Appeal. That is how.
That's very interesting. So that's how it started yesterday. So it sort of set the tone for how things were going to go. Now, take us through the applications and what they sought to achieve, and while you sat in court, what you observed and what the overall ruling is.
Okay. By making a certain statement, he says the word mistrial in quotes does not actually occur in any of our legislations. That's a very important point to make right from the beginning.
You'll recall that when we talked about the actual application after it had been filed, I made mention of my immediate mental reference of the word mistrial being American.
Yes.
Because of exposure to a lot of American, legal dramas and books I had been reading, and so I'm not surprised that but of course, being Joe Blogs, I'm thinking, maybe we do have it. So explain what the judge meant by the word mistrial not being a word in our legal framework or laws.
So she goes on to say that the circumstances under which a mistrial may occur, thereby requiring a matter to be retried and not an acquittal, is when reference to section 2854 and 286 of the Criminal and Other Offences Procedure Act 1960, Act 30. The relevant legislation states, and she quotes 2854, where the jury are not unanimous in their opinion, the justice shall, after the lapse of a time that the justice considers reasonable, discharge the jury, but a verdict of not less than 5-2 shall, in respect of an offense which is not punishable by death, be held, taken to be, and received by the court as the verdict of the whole jury.
Okay.
So even this one, it makes an exception for cases that are being tried that are not.
So if it's
punishable
a trial
death.
by jury, which is not a case in which, if found guilty, the accused person will be sentenced to death. If a certain majority, a minimum of 2,
Minimum of
a minimum of 5 rather, 5-2. If you have a
7.
exactly, so if you have a 5-2, the 5 majority will be taken as the verdict of the whole of the 7.
So, for example, if it's
But
a rape case,
Exactly.
Yes.
A 5-2 can still hold.
Yes.
So if it is one where, which is high treason,
yes,
is,
or the recent one, Afoko's case,
yeah,
murder.
yeah, murder.
Yes.
Okay. So in a murder trial where you have a jury of 7, if you even had 6-1, you can't proceed.
It's still mistrial.
It's mistrial. Okay. Thank you.
Unless, of course, the punishment is not by death.
It's not by death. Exactly.
It could be life imprisonment.
Exactly, which is why I was saying that, treason. I mean, I'm just thinking high treason is probably one of the things where, in my mind, am I right?
Yes,
Yeah.
you're not wrong.
Thank you. So if it was high treason and you had a 6-1, a mistrial will be declared. It has to be a 7-0, a unanimous decision to convict or acquit. But otherwise, a
it'll be considered
5-2, right? A 5-2 in any other case outside of a death sentence, a case where if found guilty, the sentence will be death.
Yeah.
The majority will be held as the judgment or the verdict of the 7.
Yes.
Okay, thank you.
So 286, the judge quotes again, says, where the jury is discharged, the accused shall be detained in custody or released on bail and shall be retried by another jury.
Okay.
So even when there is mistrial,
It doesn't mean that
not an acquittal.
so yes.
Okay.
So the judge comes again to state that there has been no situation where a summary trial being presided over by a single judge has resulted in the declaration of a mistrial or an order for retrial, to my knowledge.
Okay.
So she's going down into memory lane in our jurisprudence, trying to find whether there has been a precedent. And she says she can't find it.
Okay.
Okay. So the applicant has not provided such a precedent in our domestic legal framework, either by way of legislation or judicial pronouncement, except to state the broad principles of the Constitution and inherent jurisdiction. And so you
So in
see that-
essence, the application by an Ankasana, there was no case law backing it.
No. Was
In
there
respect
any
of that.
In respect of that particular-
yes,
okay,
mistrial.
all right.
So if you read the affidavit as was filed by to support the argument, you only see the quotation of constitutional provisions. And I remember that on the forum on Saturday, I raised that issue because usually you come under some rule or something, some.
There has to be a certain precedent.
So, it's not there. So, the judge again is saying that in our body of laws, as far as legislation or case law is concerned, there is no provision for the court to declare a mistrial on the basis of the alleged misconduct of a lawyer, either for the prosecution or the defense. So she was still laying the foundation to come to a conclusion. And then I see at the latter part of that part of the ruling, it says that this case has been pending. She's talking about the case of the Republic versus case Latofosen and 2 others, one standing discharge. She said this case has been pending since the charge sheet signed by Mrs. Ivona Takura-Boabisa, the Director of Public Prosecution for the Attorney General, was filed on 23rd December 2021. We have made steady progress with the prosecution, closing its case on 14th February 2023, and first accused also closing his case on the 16th of November 2023 after having called 3 witnesses. From the allegations made against the Attorney General, the inference he is supposed to have run. Oh, okay, so let me read it better. From the allegations made against the Attorney General, the interference he is supposed to have run took place when A3 was supposed to have commenced his testimony or right before that. In a trial that has run for more than 2.5 years, how can the alleged happening of a last few weeks render the jurisdiction of this court and the charges against the accused persons void? It's a question the judge is asking. In all of this, what this court has to focus on is whether the matter being canvassed are relevant to a determination of the case before it. The charges before this court in respect of the 2 accused persons are, so he recalls all the charges, which we are not going to talk about, and then comes to make a conclusion. So it says that, however, should I start from the, okay, so let me just say, so there's been no legislation in our criminal law and procedure for such a declaration of mistrial as this court is being called upon to deliver in the circumstances of this case. And there be no other legal basis, I shall decline the invitation to declare a mistrial in this case. Okay. So, simple.
And Kwaku, just a little addition to this. So that when it comes to mistrial, you recall that Wilberforce made reference to the fact that the justice said the applicant did not provide any law, rule, or whatever the case may be, to back the mistrial. Exactly. But guess what the judge went on to say? He says, the respondent, however, has rightly cited the case of Chia versus Amoa, all right, in which Corsa J, that's Justice Corsa, set out in general the possible scenarios that might amount to a mistrial and a retrial being ordered. And so now, unlike the applicant being the first accused, all right, seeking to have this whole thing cast on the basis of a mistrial, the respondent in responding indicates the grounds in case law, as far as our jurisdiction is concerned, that can result in a mistrial. And these are the things mentioned. 5 by Justice Corsa. It says, if there's a defect of jurisdiction in respect of time, place, and person. Remember that. 2, if the judgment so imperfectly worded or so ambiguous or inconsistent that they are too imperfect to amount to a verdict at all. 3, if there's the misconduct of the jury discovered after trial. 4, if there's misdirection or improper admission of evidence or failure to observe the rules of natural justice, which occasions some substantial wrong or miscarriage of justice. And then 5, where for any other reason the trial is a nullity. And guess what? This is what the justice had to say about these grounds as captured in Chia versus Samoa. It says, in our body of laws, as far as the legislation or case law is concerned, there is no provision for the court to declare a mistrial on the basis of the alleged misconduct of a trial. Sorry, of a lawyer.
A lawyer.
Either for the prosecution or the defense.
Yeah.
So, as far as our legal jurisprudence is concerned, case law provides and precedent is set, there is no basis to declare a mistrial on the premise that a lawyer in an instant case has misconducted himself or herself.
Let me ask a fabulously ignorant question. After this judgment, if, say, a mistrial is one not in the framework lexicon of our jurisprudence, and foreign to us, and all these other points that the application should have satisfied was somehow remedied, is there room for the accused persons to come back to court to say, we're applying again for this trial to be thrown out because of the person's behavior, and able to not necessarily call it a mistrial? So, I hope you get where I'm going.
Yeah. So you see, typically what you're asking for would be when a decision has been made.
Yes.
And then you are calling for a question of a decision, that has been made. That already happens.
Okay.
Just that will typically go through an appeal process.
Court. Yeah. Okay.
But in this case, and let's not mix up what the justice said. The justice is not saying that we do not have an establishment in our laws basis for which there could be a mistrial. Because in Tia versus Amua, there is
the grounds for which a mistrial is possible.
There is
has all been listed. Okay,
but not on the premise of a misconduct of a lawyer.
Whether they be for the prosecution or for the accused. Okay.
The fact that it's for both sides.
Okay.
Very important.
Fantastic.
Yes, but if you see that, and you need to establish that this is a criminal trial.
Exactly.
2 persons now.
A criminal trial that is also not by jury.
Yes.
Yes.
It's summary. It's a summary trial. So they have been charged for causing financial loss to the state under the Criminal and Other Offences Act in our country. That is simply what the court is being invited to do. So any other matters that fall outside of the remit of the case. So you see, they are for even if you went to, let's say, SRAJ or General Legal Counsel to go and establish whether the Attorney General's conduct is bad or good. Let's say that they even say it was bad. The fact that he spoke with the accused person. Let's say it was bad. Okay. Does that affect the charges that have been preferred against the accused?
So basically, it confirms what the judge said in the aftermath of that presser. That, actually, it wasn't a judge, but this was some legal minds we spoke to said, well, this thing, no matter what happens in the public domain, it's not going to affect what happens.
The
judge who said that.
She said when she was cautioning, so she called Nsem-Pii into the witness dock.
That's right.
And then cautioned him and cautioned everybody. Other lawyer associated to this case, and told them that be careful how you communicate around you ponder around this matter.
Because that one there, I know you're hot.
Because this trial is not even by jury to sway the jury in any way.
But
I am the one going to be making the decision.
And it
won't affect me in any way.
Because I will make it based on law.
I've closed my mind.
No, she's not closed her mind. You see, there's no prejudice in, she's just dealing with what's before her and making the cause by, she's closed her mind to the noise.
Public noise, yes. That's what
and she's just going to be focused on what the law says. As demonstrated in the excerpt of the ruling that you just read.
That is the reason why even in this small ruling,
Yeah.
she even takes her time to replicate all the charges.
Yeah.
And saying that this is what is before me. I'm not concerned about anything else apart from this, unless you're able to prove that these charges that are and you see normally when trials are starting, and I saw that in the case of the Republic versus and 8 others. Right from the beginning, they started challenging their charges. Right from the start of the case. Up to the point that, I think an instance, they had to go and review the charges also. If not Kwabnado, it was another case.
Yeah.
So they challenged it, and the AG was ordered to go and rephrase the charges and all that. In fact, in this case that we're talking about yesterday, the case involving the accused persons who have been arrested for the derailment of the train.
Derailment, yeah.
That train thing, those who are before the court, the state actually withdrew the charge sheet and has brought a new charge sheet.
Of abatement.
Yes.
All right. Let's get through the rest, and then we'll
see.
No more interjections for now. Get through the others, and then we'll get into it.
So see, that's one. The judge didn't take so much time on it. On the application for injunction to restrain the prosecution from any further prosecution of the instant proceedings pending the determination of the applicant's motion for mistrial. She didn't waste time at all. It was just one paragraph. So she says that, for example, she says that it says that the law is widely known that injuncting statutory bodies in the performance of their lawful duty should, if at all, be sparingly done. It has been held that the court ought to be cautious in dealing with applications for injunction when a body is entrusted with statutory discretion and not dogged its exercise with injunctions. She goes on to say that in the circumstances of this case, I find it exceptionally... Okay, so it says that in the circumstance of this case, I find no exceptional circumstance in the application to injunct the Attorney General and his office from performing this statutory duty at this late stage of the trial, especially when the court has ordered A1 to open his defense, which he has done. The application for injunction is accordingly refused on that score. So that one, we don't waste time on it at all. The court says you don't injunct statutory bodies. they have this particular one is actually a constitutional duty.
Okay.
It takes the power straight from the Constitution, and then a judge will say that a constitutional mandate cannot be performed by the constitutionally mandated person. How possible?
So this is a confirmation of the Constitution being the supreme law of the land.
Exactly.
Therefore, no action.
Be the first to know Nsem-Pii TV.